The Honorable Supreme Court of India on Tuesday, March 24, held that a person who has converted to Christianity cannot continue to claim the protections available to the scheduled castes in our country. Now, this bench comprising Justices Prashant Kumar Mishra and Justice Manmohan upheld the Andhra Pradesh High Court order and said that other than Hinduism, Sikhism, or Buddhism, a person cannot simultaneously profess and practice a religion and claim a membership of a scheduled caste at the same time. A person who professes and practices such religion for personal, social, and spiritual purposes cannot, in law, assert membership of a scheduled caste for the purpose of securing statutory benefits. Now, the two positions are mutually exclusive and contrary to the constitutional scheme. The bar, the Honorable Supreme Court of India said, is absolute and admits no exception. The order sits at the junction of two competing ideas. One is the constitutional design of the scheduled caste status, which is as much a social identity as a legal recognition defined through the Constitution Scheduled Caste Order of 1950. Now, the other is the caste based discrimination, which has been shown to persist even after conversion, particularly amongst Dalit Christians. Now, the court upheld that the loss of the SC status. And the court held actually the loss of the SC status upon conversion is not gradual, it is instant. Once the appellant converted to Christianity, the caste status which he earlier enjoyed stood eclipsed in the eyes of law. Now, the case arose from a 2021 complaint filed by Pastor Chintada Anand Paul in Andhra Pradesh village. Now, he alleged that he has been repeatedly abused using caste-based slurs, threatened with death, and physically assaulted on two occasions, one during a prayer meet and later while returning from one. Now, based on his complaint, a case was registered under the SC/ST Act, including the criminal provision of wrongful restraint, criminal intimidation, and hurt under the Indian Penal Code IPC. Now, the accused then approached the Andhra Pradesh High Court, seeking to quash the proceedings. Their case rested on a single point that the complainant had converted to Christianity years ago and had been functioning as a pastor. Therefore, he could not claim to be a member of a scheduled caste and could not invoke the SC/ST Act. The complainant countered this by relying on his caste certificate identifying him as a Hindu Mariga, or recognized scheduled caste, and argued that caste being linked to birth does not disappear with conversion. Now, for context, the Scheduled Caste and the Scheduled Tribe Prevention of Atrocities Act was enacted precisely because India's most marginalized communities, those who have historically faced caste discrimination, violence, and social exclusion, needed legal protection. Now, it creates specific offences, harsher punishments, and a dedicated court structure. Now, the issue the court had to deal with was whether that legal protection travels with a person after they have voluntarily left the community through religious conversion or not. Now, the Andhra Pradesh High Court in April 2025 had said that the caste system is alien to Christianity and that SC/ST Act is a protective legislation meant to specifically help the members of the SC/ST community. Now, the provisions of this act, it said, cannot be invoked by someone who does not fall in the ambit of that definition. And the court had also held that there were several inconsistencies and lack of corroborating evidence in the witness's statement, and also held that continuing the proceedings would serve no purpose and would amount to subjecting the accused to an unnecessary trial. Now, this is all regarding the case, and this is what Honorable Supreme Court of India had to say. Now, let us just look at the law. Now, the court's reasoning on conversion and scheduled caste status rests on a set of constitutional and statutory rules that tie caste identity to the religion a person professes. Now, this particular point is very, very important. Now, this framework, it began with the Constitution Scheduled Caste Order, which happened in 1950, which was issued under the Article 341 of our Indian Constitution. Paragraph 3 of this particular order, if you see, states that no person who professes a religion different from the Hindu, the Sikh, or the Buddhist religion shall be deemed to be the member of the scheduled caste. Now, the law, thus treats conversion to Christianity as a point at which the scheduled caste status ends. This is from 1950 we are talking about. And this classification is reinforced by the Constitution itself. Now, if you see Article 366, Section 24 of an Indian Constitution, it defines the scheduled caste as those groups notified by the President under Article 341. Now, both provisions works in tandem, and the SC/ST Prevention of Atrocities Act adopts the same definitions. The result is that the legal identity of a person as a scheduled caste is inseparable from the religion which they profess. This is the truth, and once their social membership to a community ends, the legal protection tied to it ends as well. and the SC/ST Prevention of Atrocities Act adopts the same definition as the constitutional provisions above. This means that the religious bar on SC status automatically extends to the protection and remedies available under this particular act. Now, this entire framework leads to just one conclusion. Scheduled caste legal identity is inseparable from religious identity. That's the conclusion. And once a person's social membership to SC community ends through conversion, the legal protection tied to that membership ends as well. And this is what Honorable Supreme Court of India concluded as well. Now, Honorable Supreme Court of India also held that the bench actually said, and they held that there were no claim of reconversion or re-entry into the caste community by the said person. Instead, the record showed that the appellant continues to profess Christianity and has been functioning as a pastor for over a decade. And it is also an admitted position that at the time of the alleged incident, the said individual, was conducting prayer meeting. The court said, adding that these facts leave no room for doubt about his status at the time of the incident. On constitutional terms, to profess a religion, the court said, is not just what one believes, but what one lives and presents to the world. And it said that the term profess connotes to publicly declare or practice a religion. And it is not merely a question of personal belief or personal conviction, but requires an outward manifestation of one's religious faith. Now, by that measure, the appellant's role as a pastor, leading prayers, organizing gatherings, made his position legally unambiguous. The court returned to the 1950 order and underlined its effect. It described it as a categorical and unambiguous. It bars anyone professing a religion other than Hinduism, Sikhism, or Buddhism from being treated as a member of scheduled caste. Irrespective of appellant's caste of origin, he cannot be deemed to be a member of scheduled caste, the Honorable Supreme Court of India said. Also, the effect of conversion, it added, is immediate. Once the appellant converted to Christianity, the caste status, which he earlier enjoyed, stood eclipsed in the eyes of the law, which I earlier told you. And on the caste certificate, the court drew a line between the paperwork and the law. The fact that the appellant continued to hold a certificate did not change his legal position. It said mere possession of a certificate will not be any kind of benefit. The court said, stressing that such certificates must operate in consonance with the Constitution, that is the Scheduled Caste Order of 1950. And the court also clarified that the position is different from scheduled tribes. This is a very, very important point, where religion is not the determining factor. But even there, it said identity depends on whether a person continues to be a part of the community in terms of customs and recognition or not. In this case, however, there was no such complexity. The facts were clear, and so was the law. The appellant had converted, continued to practice Christianity publicly, and had not returned to his original fold, which is why the person will not be treated as a part of scheduled caste community. Now, this is a landmark order, and what unfolds after this is for us to see. I hope you gain some new perspective from this session, and this entire case is very clear in front of your eyes. Do let me know what are your views on this particular thing. Now, do let me know what are your views regarding this in the comment section. I'll be happy to read them. All the very best and have a beautiful day. Thank you.